All right, welcome back to the Academy of States 3.0. If you thought you knew everything there was to know about Article 5, you know you were in for a treat from this last panel, and I can tell you're in for a treat for the next one. As we've talked about, these are fascinating times. We have so much to look forward to, and the opportunity for the states to take a leading role, to have their hands on the wheel as we look at the problems that we're facing. In this next panel, we are looking at delegate instruction and oversight. How do we do this thing called an Article 5 Convention of States for proposing amendments? On this panel, we're going to first hear from Michael Stern. And Michael's resume is long and distinguished. He's a constitutional attorney and co-founder of the Balanced Budget Amendment Task Force. Specializes in legal issues that affect Congress and the legislative process. Particularly in constitutional amendments, constitutional ethics, elections, investigations. Mr. Stern was senior counsel in both the U.S. House of Representatives and the U.S. Senate. And once we get to this trigger point of 34 states, to have that kind of legal analysis is going to be very critical. Mr. Stern was senior counsel to the U.S. House of Representatives from 96 to 2004. He also served as deputy staff director for investigations on the Senate Committee of Homeland Security, special counsel to the House Permanent Select Committee, and co-chairs the D.C. Bar's Administrative Law and Agency Practice section, and serves on the ABA Task Force for Lobbying and Reform. And Mr. Guldenschuh, his involvement with the Article 5 movement goes back a long number of years as well. David Guldenschuh, leader in the nationwide movement to get a convention of states pursuant to Article 5 of the Constitution. David was involved in proposing amendments to the Constitution to rein in federal government, to balance power, and to return that balance of power back to the states. David is the publisher of the Article 5 Convention Legislative Progress Report, which is a tracker of all things Article 5 and the efforts and the progress that's being made in those. And David was instrumental in Georgia becoming the very first state to pass the Convention of States application for an Article 5 Convention of States. David has served as special counsel to the Balanced Budget Amendment Task Force and is a board of policy advisors of Heartland Institute. David's a graduate of cum laude of the University of Notre Dame Law School, has been mentioned in Georgia's top lawyers. And David's also very involved and instrumental in the formation and ongoing role with the Phoenix Correspondence Commission that we'll hear more about later, which came out of the Phoenix Convention that happened in 2017, the Rules Convention, to have an ongoing organizing group of states to work on this process of how do we get to a convention of states. And so with that, we will first hear from Mr. Michael Stern, and following that, we'll then hear from David Guldenschuh. Mr. Stern, thank you.
Thank you very much, Ken. I see our PowerPoint was so excited it got started early. Let me go back to the... Okay, so we're here to talk about the delegate oversight and instruction aspect of the Article 5 Convention. It is important to understand, however, the broader context of Article 5 and how it works in order to fully appreciate how delegate oversight and instruction works. So let's start with just a very quick overview, which I'm sure all the people in this room are very familiar with. The process starts with the states applying for a convention. Those applications go to Congress. Once there's the requisite number of applications, Congress is required to call a convention. So that's 2/3 of the states, or 34 applications are required. Then the convention proposes amendments. The Congress selects the method of ratification, which could be either by conventions in the states, as we heard, or by the state legislatures themselves. And then the states are responsible for ratification. And that, of course, as we all know, requires 3/4 or 38 states in order to ratify an amendment. So the application process in the states, again, as mentioned, 34 state legislatures are required in order to trigger the convention call. Each state legislature, therefore, has the opportunity to pass a application whenever it believes that a convention is called for. It can pass more than one resolution on different subjects, or it can pass a general unlimited resolution as well. And so each state legislature has the responsibility of deciding, do we want a convention? If so, should it be limited? How should it be limited? Congress then must determine the validity of each resolution, because it has to at least know that a resolution that it receives was received by a state legislature, was passed by a state legislature, and it must determine which of these resolutions aggregate. So Congress has the responsibility of counting, and as we know, perhaps from the example of the Electoral College, sometimes even that very simple task can become complicated. So as part of their preparation for a convention, each state may establish the manner of appointment of delegates, which is what we heard about in the last presentation. And in addition, each state may pass a special law, which may be combined with the method of appointment, but which places certain limitations on the delegates, on their delegates to a convention. And in addition to that, states may appoint committees for the purposes, this is all in preparation for a convention. States may appoint committees to communicate with other states about what they would like to see in a convention, how they'd like to see the convention structured, and they can meet to discuss even possible rules and procedures for a convention. We'll hear about some of those efforts when David Guldenschuh comes to speak. So what kinds of things might you put in a Delegate Limitation Act? Here's some examples, which, again, we've heard some in the prior discussion. We've heard some of these mentioned as things that have been historically done either by the pre-ratification conventions that, including the Philadelphia Convention and the Annapolis Convention, so forth, as well as different types of conventions. Not though there's never been an Article 5 convention, there have been different types of conventions throughout our history. Sam mentioned a number of those, and so there are some historical precedents for basically all of these examples, but they differ in terms of whether they are things that came out of the pre-ratification conventions or whether they're more modern innovations. So the idea of a Delegate Limitation Act was actually founded or modeled on the Uniform Faithful Elector Act. And I can say that because I was the one who actually came up with the idea, and that's where I got the idea from, was from the fact that again, we mentioned the Uniform Law Commissioners. They had come up with an act designed specifically to enable the states to limit the authority of their presidential electors. And so there's an analogy there, which seems obvious, right? So when states appoint electors for the purpose of the Electoral College, those electors are pledged to vote either for one slate of candidates or the other. Typically, they take an oath to do that, or in many states they take an oath to do that, and then many states have also gone further and actually imposed penalties for electors who violate those pledges. So the states had a uniform act that they could adopt that was proposed by the Uniform Law Commissioners, and the thought was, well, the analogy here to delegates to an Article 5 convention is very clear, right? States are responsible, just as they're responsible for determining the method of appointing electors, they're responsible for determining the method of appointing their delegates to an Article 5 convention. They have the authority historically to limit to place limitations on the authority of their delegates to a convention, and how do they make sure that the delegates live up to those limitations? Well, they can impose sanctions. So a typical Delegate Limitation Act might include requiring the delegate to take an oath, to have credentials or commissions, which is historically the way commissioners or delegates to conventions were appointed, which they would have credentials from their state legislatures saying you're authorized to be a delegate to this convention, and this is the limit of your authority. So then another possible provision is the automatic removal and replacement of a delegate who violates that commission. Now, I actually was not aware prior to today that there was a historical example of that even pre or during the ratification process. I learned that from Sam's presentation, but it is something that has been included in these Delegate Limitation Acts, and that certainly is an additional historical support for including that kind of provision. Instructions, again, is something that historically is well grounded in pre-ratification practice, and then you can also have a requirement that delegates support certain convention rules, and you can have criminal or civil penalties for violation of the oath. So I've already mentioned the fact that the DLAs were modeled on the Uniform Faithful Presidential Elector Act. Well, before I get to that, so I want to talk a little bit more about that analogy between the presidential electors and the delegates to the Article 5 convention. But I want to talk about it not so much from a strictly legal perspective. I want to talk to you more about this from the perspective of the norms and the cultural expectations that are established in states. And I think the presidential elector example is very helpful in that regard. So all of these limitations in Delegate Limitation Act have historical provenance of one type or another. But there's no question that there's never been an Article 5 convention, and so there's never been any direct case law on whether any of these individual provisions is valid. There's undoubtedly the possibility that some of them could be challenged, as we will see they were in the case of presidential electors. But my view is it doesn't really make that much difference whether you think that, well, I believe all of these limitations that I mentioned are legally defensible. I don't think it makes that much difference whether you think one is a little more risky or than the other from the point of view of potential legal invalidity, and I want to explain why. So looking at the examples of the presidential electors, and going back now, as we'll see in a minute, and Sam mentioned in his presentation, there's been some recent case law on this question, but I want to go back to the period before this case law was decided. Back in 2017, we had a presidential election that was quite close and very controversial, and you may remember that there was an effort following the 2016 presidential election to have presidential electors violate their pledges and vote for somebody other than one of the two candidates who were who they'd been pledged to vote for. They called that the effort the Hamilton electors, and the argument was that constitutionally, the presidential electors had the authority to vote for whoever they thought was best qualified, and they were not, historically, the overwhelming majority of presidential electors had voted for who they were pledged to vote for, or even before there were pledges, who they said they were going to vote for when they were appointed. Nonetheless, that was not legally required. This was the argument made by the Hamilton electors. And so they went to different electors in different states and said, you don't have to vote the way you're pledged. Now, in many cases, the states that these electors were from did not have laws that penalized them at all for violating their pledge. Some states, I think a small number of states, didn't even require them to pledge, so they had no legal limitations whatsoever. Other states, there was a pledge, but there was nothing that could be done to them. And then some states did provide for sanctions, either through the automatic removal process, which was what Colorado did, or by placing a fairly small financial penalty, which is what Washington State did. But the argument was that those limitations are not constitutionally enforceable, right? Because you, as a legislator, as an elector, have the authority and also the responsibility to make this choice, and you can be advised by the vote and what the people of your state think, but you ultimately have the constitutional responsibility to do what you think is right. Now, that argument did not work, and you have to think a little bit about why. So it's certainly true that throughout historically, a very few number of presidential electors had actually voted differently than how they were pledged or had promised to vote. And in many of those cases, there were very extraordinary circumstances, like the person that they promised to vote for had died before the Electoral College met, which is, I think we'd all agree, a fairly understandable reason that you might depart from from what you had said. But the argument was, and the reason there was a law such as the Uniform Faithful Presidential Electors Act was, well, sure, that's true in the ordinary presidential election, but supposing we have something really unusual, a perfect storm. And they gave a few examples of the kinds of things that might happen in a presidential election where you might have reason to doubt that the presidential electors will do what they say. They said, just to make sure that that doesn't happen, we need, you should adopt this kind of law to limit it. And in 2016, essentially everything that they said they were worried about happening happened. You had a candidate who won the Electoral College but did not win the popular vote. You had very close margins in critical states that would have changed the electoral outcome. You had a candidate who was extremely controversial even in his own party. And you had negative stories, scandals that broke right before and after the election itself that potentially could influence electors to violate their pledges. And yet, with all of that happening, the Hamilton electors did not succeed in shifting more than a very tiny number of electors, far fewer than they needed to actually change the outcome. So why is that? I think the laws that were on the books certainly play a role, but I don't think that's the main reason. I think the main reason is, frankly, by virtue of how presidential electors are selected, and by virtue of the fact that they promise to do something, and by virtue of the fact that the people from their friends and their community expect them to do what they say, that has an enormous influence on what they will do. And that is, it really would take, even laws aside, and I think laws play a role, but even if there's no penalty, that it's just very unlikely they're going to depart from what they have pledged to do. I wrote a blog post about this in 2017, and I was struck by one of the electors from Oklahoma. Maybe some of you know him, but he was asked about this and why he had not succumbed to the blandishments to change his vote. And he said, I was not particularly enamored of this was a Republican elector, not surprisingly, the Republican nominee, and would have preferred someone else. But there was no way that I was going to depart from what the voters of Oklahoma told me to do. And just there, and he said, I'm not saying there's never any situation where I would do that, but and this is the quote from him. He said, let's say that somehow the American people nominated a guy who murdered 47 people, carved them in a ditch, and hadn't been caught yet, and he got nominated for president. Well, then I might change my position. So that's what it would take to get someone to depart from the presidential elector nomination pledge. I think a similar thing is true of delegates to an Article 5 convention. That's why what we heard about how they're appointed is going to be important, right? But they're going to be appointed with expectations about how they're going to conduct themselves. They're going to take an oath. They're going to have commissions. They're going to be people who, if they don't come directly out of the legislature, they're at least going to have a bond of trust and confidence probably with the legislature. And so it's just very unlikely that they are going to, even laws aside, that they are going to depart from what they are pledged to do. Now, let me talk about the case law which came after 2017, which I think is also helpful because it further enhances this restriction on presidential electors. I think much of the reasoning, while not directly applicable to Article 5, is certainly supportive of these delegate limitation laws and in the Article 5 context. So this case, which is called Chiafalo, 2020 case, Supreme Court case, that came out of the election of 2016 and involved electors from, Sam mentioned, I think, Washington State, and also there was a companion case involving Colorado. In Washington, the faithful elector law imposed a $1,000 penalty on anyone who violated the oath, and in Colorado, it was an automatic replacement process. So the court looked at the text of Article 2, which provides for the presidential electors, and it said, look, there's nothing in Article 2 that prohibits states from taking away the discretion of the electors and requiring them to vote for particular candidates. And it says the power to appoint an elector in any manner includes the power to condition his appointment, that is to say what the elector must do for the appointment to take effect. Now, we'll get to the concurrence by Justice Thomas in a second, and I think he points out fairly that some of these limitations are more difficult to justify as a condition of appointment than others. So if you go back to our Delegate Limitation Act, the oath and the credentials are clearly tied to the appointment. Other things like imposing a fine or criminal penalties might be a little more difficult, but the majority thought that even the fine was within the power to appoint. So if you apply that reasoning to the Delegate Limitation Act, where the states have the power, with some, now we have to make some caveat here, because while it is I think the pretty, certainly historical practice and the views of many constitutional scholars is that it's properly the state legislatures who get to appoint their delegates. There is, as was mentioned, some thinking that Congress could, if it chose, take that over. But I think that's wrong. We don't need to get into a legal discussion of that. Let's just say that in the absence of congressional action, it will definitely be the state legislatures that are responsible. And we had the analogy of the state ratification conventions in for the repeal of prohibition, where there was some discussion of the same issue. Should Congress step in and do that? And some people said, no, that would be unconstitutional. Some people said Congress could do it, but in the end, Congress did not do it. And the states passed their own laws, and they basically they decided that you would either be pledged to vote for ratification or against it. There was generally, I'm not even sure, it may have been totally, but almost every state, I think, had an election to decide which candidate they wanted. And then there were, in some states, there were even penalties if you violated that. So it was basically the same idea as the presidential electors. And so we see from that in the fact that the state legislatures control the appointment process also supports the fact that they can limit the delegates and require them to conform to their oath or conform to the credentials. Majority relies heavily in its analysis on the 2 centuries of historical practice under the presidential elector provisions. The Article 5 is, of course, a little different because we've never had an Article 5 convention, but we do have this rich history that we've discussed, which includes the pre-ratification conventions, the state ratification conventions under Article 5, and then many other examples of things that the Philadelphia Convention, we have the state legislation now under, which David Guldenschuh will talk about more specifically, with Delegate Limitation Acts and many other things that are generally supportive of this idea that the legislatures can limit their delegates. So let's just briefly touch on Justice Thomas's concurrence. He didn't agree with the majority that you could infer in Article 2 itself the power to limit presidential electors. But what he said was the Article 2 doesn't say one way or the other whether you can limit them, and therefore the states, by virtue of the structure of our system and by the 10th Amendment, have that authority by default. And of course, that reasoning would directly apply to Article 5, because in Article 5 there is simply nothing about, all it says is there's a convention for proposing amendments. It says nothing at all about how that convention should be structured. So Justice Thomas, joined by Justice Gorsuch, would clearly say that the states have these powers. You have to do a little more work to infer that from the majority, but it's at least generally supportive of the idea. Okay, so that basically covers the Chiafalo analysis. And let me just finish with a brief recap of what I said earlier, which is that an important point of these laws, it's not just the limitations, the legal limits, but it's really that you're reinforcing these norms and conventions that I referred to before. You're establishing that delegates are supposed to do what they are told to do by the state legislature, what they promise to do, and that is a powerful, as we see in the presidential elector example, that is a powerful pressure even beyond the actual legal penalties. And again, there's a similarity between the presidential electors and the Article 5 Convention in that there's a huge collective action problem if you want to try to get any kind of runaway college or runaway convention, because you need to get people who are voting in different state delegations to flip. That's not something that it's easy to get people to do. If you just think about it, if you're the first person in your state's presidential electors or your state's delegate, your state's delegate group, you don't want to get out on a limb and say, I'm going to violate my oath, because you're subject to your state's laws, the social pressure from your state. The fact that somebody else in a different state might have flipped really doesn't mean very much to you. And so the challenge is you got to flip a whole bunch of different states with different kinds of laws, and you got to do it under the countervailing incentive of these social pressures and norms and legal penalties. And there really is no assurance, even if you were able to do that, you would be facing, ultimately, neither the presidential electors nor the convention had the last word. The convention's work has to go to Congress. Presidential electors' votes go to Congress. There's no guarantee that Congress would accept these faithless votes, even if it actually changed the outcome. So for all those reasons, I think that these delegate limitation laws are likely to be extremely effective. Let me turn it over to David Guldenschuh.
Thank you, Mike. I'd like to take what Mike just said and put it in a real life perspective. We've never had an Article 5 convention before. If we ever have one, I can tell you right now, it will be the greatest political event in your lifetime. It'll be the equivalent of the Olympics coming to Denver, like when the Olympics came to Atlanta. Greatest event in the history of Atlanta in my lifetime. And it'll be that way because we've never had one of these conventions before. And it's going to be called this Constitutional Convention. I call it an Article 5 convention. I like to be more specific about it, because when you say Constitutional Convention, you open yourself up to a lot of potential blathering from folks that are opposed to it. But this is something much bigger than what it is. It's limited to whatever the call was. But so picture for a moment this Article 5 convention. We get to 34 states for a convention. And let's say the Convention of States project gets there, so it's a much broader convention. But it really doesn't matter. It could be the Balanced Budget Amendment Group. It could be term limits. And all of a sudden, if you think there's been a lot of press about this up till now, and Insider just came out with a great story on all this that I recommend to you to go read about how horrible these people are on the left and the right trying to propose one. But think about it. All this is going to be, and I can just imagine what's his name, Governor Gavin Newsom out in California. You know, he's got to appoint somebody to this convention. This is a constitutional convention. So he goes out and he appoints his good buddy Matt Damon to be a delegate to this convention. And Matt Damon is now going to be the next Alexander Hamilton or James Madison. And that's the way it's going to be billed all over the country. So you're going to have that kind of publicity going on. The cities, Denver, Atlanta, LA, New York, Philadelphia, they're going to be bidding to get this convention. They're going to, they're going to want it. It's going to bring it's going to be like an Olympics coming to your city. And so it is in that focus of the media that the concept that a delegate is going to go outside, or commissioner is going to go outside the limitations that have been put on them, that you have to think about. And it's just it's just a complete and total fantasy that you could do that. And then if you go even further, and I'm really kind of following up Mike on the great base you said, the concept to be, okay, with our presidential electors, we've seen, there's maybe a couple of dozen over the lifetime of our country that have ever cast a vote contrary to what they were obligated to do. And the concept that you could get, you got state delegations, they have one vote. So you have 5 people, 7 people from that state. You've got to get a majority of that state delegation to potentially subject itself to a criminal penalty, recall, violating an oath, all these things under this scrutiny. You've got to get a majority of them to go outside their commission. And then you've got to get a majority of the states to do it. So this whole concept that one of these conventions could run away, that it could meet and just go nuts. The example I love to give is, if it happens, it's going to happen here in Denver. And during one of those lunches that they go to, somebody's going to have to serve some brownies. And all those delegates are going to come back and they're feeling really good, and somebody's going to make some great suggestion to go another way. And maybe then, there's a 1 out of 1,000 chance that something could happen. And we've got examples that I'm going to talk about as we move forward. So I wanted to expound upon that, as Mike brought it up, about norms and conventions, the way things work. The concept that something could go south is just inconceivable to anyone who really pays attention to this. But we can go further. Let's look at, we've been talking a lot about, well, we can compare it to one thing or another, but let's talk about what's actually out there. There are 15 states, and it depends on how you count, because some states will pass an application, and within the application itself, they'll put limitations. So you can vary on how you do this. There's probably 15 states, depending on how you count, certainly 14 for sure, that have passed delegate limitation acts already. They're either part of their delegate selection act, or they are actual separate acts. And so we've already got 15 in place. And you're going to see a document later, as I move on, you're going to see a document where another 7 states just this past legislative session considered passing these kinds of acts. So we're already up almost, if we get to 26 states, it's now an impossibility, because you're going to have a majority of states that have limitations in place. So we're at around 15 now. There's been another 7 to talk about it. And of those 15 that have passed selection acts, at least 12 of those, in those acts, there were provisions for directions and limitations on the delegates. And you see that list right here. So we actually have hardcore information we can go to and look at for how this process is performed. Some of those states require oaths And I've given you those here: Alaska, Florida, Georgia, Oklahoma, South Dakota, Tennessee, Texas, Utah, and Wyoming. Go further. Every single one that has passed one of these provisions had a provision for the recall of the delegate if the delegate does not properly act consistent with their commission. So again, states seem to be uniform on that matter. Then there are the states that provide for civil or criminal penalties for violation of delegate oaths or instructions. We have the tough one is Utah, a felony up to 6 years that you could serve. They go light on the sentence. Oklahoma, on the other hand, has a $10,000 fine in place. Most of them are in the five years, 5,000 range. Tennessee has a misdemeanor in place and a $1,000 fine. So, and then we have in place some sample delegation bills. Now, I want to I'm going to split for just a second to comment a little bit on, again, why we're comfortable that we can put these things in place. In addition to the great legal scholarship that you just received from Mike, if we look at Article 5 and we look, really the Article 5 movement really got started in 2010. The renewal of it got started in 2010 when the Goldwater Institute in Arizona commissioned Rob Natelson to write some articles on Article 5. What is the history that's out there? Is there any truth to this runaway issue and things of that nature? And Rob is almost singularly responsible for creating the current Article 5 movement that is out there. He wrote a series of 3 articles, and in that he went back and analyzed, and the theory up to that point was there's never been an Article 5 convention, so there's no case law on it. Well, actually there is, and Rob went back and he investigated. There's been over 40 cases that have dealt with some issue that had to deal with Article 5, and it's made it to the Supreme Court before. And the United States Supreme Court has said, when we look at Article 5, we go back to what the founders intended when they put that into the Constitution. What did they mean by a convention for proposing amendments? And at that time in 1787, when the Constitution was written, there had been almost one convention a year had been held since 1776. And the founders had numerous conventions to look at, and they were very familiar with what the process was, so they didn't put a lot of detail in the Constitution because it was already there from the practice that they had in place at the time. One state, one vote. The state controls the process for selecting the delegates as well as for limiting them. And if you look at the 1787 convention, which I totally agree, Sam, is not a good example for Article 5, but if you look at it, there were 13. The invitation went out to all 13 states. All but Rhode Island showed up. Massachusetts and New York put limitations on their delegates. They said that they were limited to proposing amendments to the Articles of Confederation. They were not given the exigencies language that Sam referred to. And as a result, when fairly soon in the convention they started talking about totally new plans for just writing a new constitution, both the Massachusetts and New York delegates had a little heartburn over that. 2 of the New York delegates, I believe, returned to New York. Hamilton stayed. They kind of came up with this ruse that Hamilton would be there as a citizen of New York as opposed to an appointee. The Massachusetts delegates did ultimately, 2 of them ultimately left, but we don't think it was because of that. And I think one ended up signing the Constitution. But the problem existed in 1787, and they took care of it. So, so we know from the Supreme Court and other constitutional jurisprudence that we look to what the mechanism was in place at the time the Constitution was written. It was originalism before originalism really kind of came to fruition with Justice Scalia, and so we really have a lot of jurisprudence to look at and follow. So in addition to the presidential electors, which is a very, very good standard to follow, and it is extremely applicable, we also have in place Supreme Court precedent. So we have in place the No Runaway Article 5 Conventions Act. I'm not sure if this is the same thing as, I doubt this is yours. I don't think yours is, this is written more in common man language somewhat, but there's multiple proposed, and we'll, I'm sure, get to the website. There's multiple models for how you would do both the Selections and Limitations Act. This one provides, again, for you to require an oath and to make it subject to criminal penalties if it is not followed. So in addition to the laws that we have in place, in addition to the jurisprudence that we have in place regarding limitations, we also have specific examples of a convention working in practice. Vicki, I think, mentioned multiple conventions that have occurred before. The Colorado River Commission, which is obviously the equivalent of a commission, etc. But in 2017, the state of Arizona called upon all 50 states to meet in Arizona in September for the purpose of holding a convention of states. This was not an Article 5, this is just a regular state convention that can be held, for holding that convention for the purpose of proposing rules for a future balanced budget amendment convention. That call went out to all 50 states, and it was the 19 states formally appointed delegates to the convention. Another 8 states sent observers to the convention. And it was the first national convention of states held since 1861. There had been regional conventions held, but not a national one. The 1861 convention was called primarily to try to stave off the Civil War. They did, in fact, propose a very lengthy amendment that they sent to Congress. It was not an Article 5, but it was very close to an Article 5 convention. They proposed an amendment. They sent it to Congress. I think there were 7 states within the South slaveholding states, and then another 7 or 8 of the northern states that attended that convention. Former President John Tyler was the chair of that convention. They did their work. They sent it to Congress. Congress was not able to reach an agreement on proposing an amendment, and we had a civil war where 600,000 lives were lost. This was the first national convention held since then. The purpose to draft a set of rules. Senator Kelly Townsend, she was Representative Kelly Townsend at the time. She's now Senator Kelly Townsend from Arizona, was the key person there involved in setting up the convention. The Vice President of the convention was Ken Ivory, who's here today, and for some reason they elected some stupid lawyer from Georgia to be secretary. So actually that was the job I wanted, because I got to be responsible for making sure that the convention journal had all of the significant information that we needed in it. And that convention established a set of rules for future conventions. And I've cited to the website where you can go to get those rules. The booklet for the convention is probably about 2 to 3 inches thick, because it has literally a transcript of every single committee hearing that was held, everything that happened on the floor. Nothing was left out, thanks to that brilliant secretary that they elected for that convention. So anyway, but it set up a set of rules for a convention. And Article 1 of the rules, um, um, I'll go into in just a second, but it precludes the assembly from acting beyond its scope. And that's a rule that, as we'll see, can't be repealed, can't be waived, can't be suspended. And then they established the Phoenix Correspondence Commission, which we'll talk about in just a little bit. So here's the key rule that I was talking about that came out of that Article 1 convention. And the important thing is this: it says it refers to the fact that the power of the delegates comes from the scope of the commission that they're given. They derive their authority from the applications adopted by the states. And then it goes on to say that the convention and the delegates have no authority to propose an amendment or any amendments beyond the subject of the call. And then it provides that article, which includes that limited authority, cannot be amended or suspended. Now, this is just a proposed set of rules. When the Article 5 convention is ultimately called, it will have to set its own set of rules, as occurs at every legislature when it starts a particular cycle. They set their own rules. But they have in place a national convention of states which came together to draft a set of rules and put a set of rules in place. So they have a lot of some pretty good authority to get them started in this process. The second thing that convention did, and let me take one little thing that I recall from the convention. I know, Ken, I'd be interested in any observations you may have when we get to the discussion part of this. There were other, I think, Neil, you were a delegate to that convention. There may be other folks here who were involved. But I recall, again, the concern about the limitations that exist. Well, when each of these people came, we collected each of their, to the extent that there were commissions or instructions, we collected those, or I did as the secretary, to keep track of them, just to have them, and they're recorded in the journal. And certainly I would anticipate that would happen. It would be much more detailed instructions in the future. But at this convention, I can recall they were on the floor, they were debating the rules, and as I recall, a delegate from one of the northeastern states stood up, I'm going to leave it at that, stood up and proposed, why don't we're spending too much time on this BBA stuff. Let's move on to some, we need to do a set of rules for anything or something to that. He wanted to go beyond the scope. And I remember when that happened, there was this massive groan within the assembly. And the guy, just everyone literally shot him down. He was found out of order. It was the only time it happened in the entire convention. So we actually have in place a convention of states that would be very, very similar to what an Article 5 convention would look like. Largely, most of the delegates were state representatives or senators. And they come, and when they come together, they're used to operating pursuant to a set of rules. And so they follow those rules. And when they get outside the rules, they're unfortunately used to getting shot down. And they were shot down here when it happened. And so, again, if you kind of project ahead of what would an Article 5 convention look like, once again, I think the vast majority of the delegates would be state office holders. And again, when you come together, you can literally watch it within the room. They're looking for a set of rules, and they follow that set of rules largely. And you're certainly not going to get any significant percentage of people to try to go outside those rules. So I think another important element of putting into, as you contemplate your limitations, know that in addition, you can put the limitations, as we said, in your application itself. That happens. You can pass a limitations act that actually allows for that and is even more specific. chances are you're going to several states have set up actual committees to direct the delegates to be on call 24/7, that when they go, if something comes up, how do they address that? So you've got them in place. And then we have the Phoenix Correspondence Commission that was established. Its purpose is to create a liaison and open suggestions between Congress and between the states and then the people themselves to deal with these issues. And I would anticipate that if an Article 5 convention, when we get to that point, the Phoenix Correspondence Commission will be very, very involved in actually working with Congress, testifying before Congress. We're looking to do that. Ken has been a member of that. I'm a member of it now, of helping Congress put together the call, the place, and the call for the convention, of putting together what the call will actually say, word for word. That we would be working closely, and that this commission is available to the states for us to be there to help you. And we're asking each state legislature. We've got 20 states, I think, currently represented. We're now looking to get all 50 represented. If they don't appoint somebody, we're going to appoint somebody for them. So we've got that going on, and I think Bruce Lee, our executive director, is going to talk a little bit more about that. But it's an important body that can play a big role in, again, assuring that your limitation acts are followed. Again, this is a report that I do that talks about what the status is, but the blue line, or above the blue line, the white line, is actually a reflection of the delegate selection bill that the states where they passed in this past session, where they were active, and how far they got. So in concluding, then, an Article 5 convention, this is one last thing, can self-police itself. And I would envision that when we get to a convention, that again, those commissions will come in, they will go to, they'll be recorded in the journal, they'll go to your secretary, and I would envision putting in place a mechanism within the convention where you have a matrix of what you can and can't do. And if a particular commissioner from a particular state goes outside that matrix, either your sergeant at arms or your secretary brings it to the attention of your presiding chair, or brings it to the attention of the sergeant at arms or the parliamentarian, and the convention itself can act to keep it from happening. A convention has the power to self-police itself. So hopefully at this point you can see that there are enormous protections in place for one of these conventions to take care of itself. And I think Mike has 2 or 3 more slides that he wants to finish up. And I think we're almost out of town.
I will be very brief. So yeah, the only other point that I wanted to make, which follows on with the point about the Delegate Limitation Act being very effective and really almost not mattering how many different of these legal issues you put, or legal sanctions you put in there, because the base case is that the delegates are going to do what they're expected to do, even without the sanctions. I think the one thing that state legislatures should think about is about the danger of going too far, which is you over-prescribe to your delegates and make it difficult for them to reach an agreement at all, right? They're so worried about getting crosswise of their principles that they can't negotiate an agreement. And I think that is maybe the bigger risk that you need to think about when you're drafting the Delegate Limitation Act. And you might just think about it as 3 possibilities of how your delegates will act. One is the delegate has a broad discretion to act as your emissary, as long as they stay within the scope of the application. The second is they have discretion, but you want them to report back and make them sure that they are checking with the legislature, maybe through a special committee that has been set up. And then the third is they have very little discretion. They're really just there to report back and take orders. And it's not necessarily that one is right or wrong. It may depend on your state's view of the particular convention, right? If your state has applied for this convention, you can assume you probably want to try to give it the best chance to succeed. If you didn't apply, maybe you want to be on the more cautious side and hold the reins closer. But I think that's one thing that should be also considered in drafting this law. And I will stop there.
Great. Well, let's give these gentlemen a hand. All right. So do we have any questions from the audience to start with? I haven't seen any cards yet, and I'll go with questions until we hear from you. And if you do, feel free to raise your hand, and we'll go from there. So to start out with, Mike and David, and thank you very much. I'm so grateful for the information. To your point, David, we had a similar thing at the Williamsburg Convention that I was privileged to chair, and we had someone bring up a point, and as the chair, I ruled him out of order, and the convention honored my ruling. They could have overruled my ruling, but they didn't. And had I ruled him in order, they could have overruled my decision and by a vote. And as you say, we deal in committees and do that all the time. What I want to throw out to both of you right now is the role of preparation. What does preparation look like for legislators? We're maybe on the cusp. We know things are getting out of control. We know that the HCR 101 was filed in Congress by Representative Jody Arrington from Texas. What does preparation look like, and what is the best practice for legislators to prepare for an Article 5 convention?
Well, I mean, I would simply say we've got the act there. There's multiple examples to use. And whether you're a pro Article 5 legislature or not, regardless, you should put this into place to ensure that when the time comes, you have a mechanism to select. You want to be represented there, and you have a mechanism to instruct those delegates.
I would say that in addition to that, coming to meetings like this, obviously, is one very important preparation. But the other way is through the committee structure, which is a typical way that legislatures deal with issues. Having a committee in the legislature, or each house, or joint committee, however they want to structure it, that has responsibility for this area, and therefore starts to accumulate the expertise and knowledge that will be needed.
Okay, so let's assume 2/3 of the application, Congress issues the call, we know the time and place, they've done the bidding war over where they go and who wants to get the convention. Walk through just in overview, outline fashion, what happens first? How do you walk through what happens in a convention? How do you get to a proposal or not a proposal from a convention?
I defer to the secretary of the Phoenix.
Yeah, I mean, the first thing that's going to happen is there's going to be a political process where somebody's going to want to be chair of the convention, et cetera. So you're going to have to go through that. Again, this is where I see the Phoenix Correspondence Commission coming into play. It's got already 50 people from the states that are representatives, maybe 100 that are very familiar with the process. So, Congress names a time and place, and then a committee will have to go together for that state to organize it all. And then I would again think the Phoenix Correspondence Commission would play a key role in that. And then you just day and time you meet. The president of the Senate or Speaker of the House for that state will probably call that convention to order. And once the officers are elected, then they will take over and run the convention just like you would any legislative session.
Right. And as you mentioned, I mean, step one is adopt the rules of the convention. And in Phoenix, we had a convention for proposing rules for a convention. And even then, the first step was to adopt the rules of the rules convention, right? Mm-hmm. And you can kind of know where that convention is going to go. If it was going to go astray, assuming it could, you would know within the first day, because you've got to adopt the rules. And as you mentioned, within the rules of that Phoenix convention, was the delegates could not propose things outside the scope of their call. And so that rule process would be essential, and you would know where that's going. And then the rest, so you adopt the rules, the rest of the convention, just basic elements. Where does it go?
I think and the rules that were adopted in Phoenix point this out. But there are certain committees. You're going to have a style committee. You're going to have a credentialing committee. You're going to have a committee for each topic, each proposed amendment. I would think that there would be a series of this is going to take place over 2 to 3 weeks. In advance of the convention, depending on how much time you're going to have experts that you're going to call in to talk about, for example, a balanced budget amendment, or and then that's going to come into each of these committees, and just like you do in a regular legislature, you call out what you're not going to go any further with, and you eventually bring it to the floor and through the committee process, and then you have a vote.
Yeah, and I like the way you pointed that out, that at a convention, you would have to get a majority of that delegation to go astray from what they were sent to do. Then you would have to get a majority of the delegations. Then you'd still, once it were sent out, you would have to get 38 states to go along with whatever. So it's all in the sunshine that we live in the modern era. Michael, I want to ask you something. You've touched on this, but I'd like to know a little bit more. If you could touch on just the dynamics of control versus deliberation, right? And so you've got this ability as the state, the legislature as principal, the delegates as their agent, acting as a group. And if you could speak a little bit more to that idea of control versus deliberation in this kind of setting.
Right. Well, I think that for those who want the convention to be successful, right, and particularly the first convention, it's going to be critical that there be broad support, right, that it be a topic that there's a potential to reach an agreement that has that kind of broad support, and then hopefully that they can actually agree on an amendment that has the potential for being ratified by 3/4 of the delegate of the state. So in order to sort of work backward from that objective, right, you can't have a situation, I don't think, where half the states basically say we're only going to vote for this amendment. It is worded exactly this way, right? There's no way to reach agreement if that's the case. So you want obviously there's a great concern, particularly when we've not had one of these before, that we want to make sure it does not do something that we're not expecting. But on the other hand, you got to give them enough leeway that they can be successful, because that's ultimately the goal. Right? I think you had a question about that.
Yes.
Thanks. First, a real quick comment and then a question. You had mentioned the New Hampshire story. I got that, as well as another story from the documentary history of the ratification of the Constitution. The New Hampshire volume came out a few years ago. Also, in that same source, they talked about there were several towns that appointed similar commissions to oversee their delegates at that time. And also sometimes commissions to write the instructions for those delegates, and unfortunately most of those towns neglected to include what instructions those commissions wrote. They just said the commissions existed, and then that was the end of the record. And then the question I had, in 1933, several of the states, quite a few of the states, in their legislation included rules that would get the various conventions started, ranging from the bare bones to, in the state of Washington, where they said just adopt the Senate rules. I'm wondering if you've thought about whether or not something like that would be appropriate in model legislation that would, like, say the delegates should vote for, you can't mandate the rules in state legislation, but you could mandate that your delegates vote for certain bare bones rules.
Well, I think you can do that, and I think some of the delegate limitation laws do support to require them to vote for some procedures. I think that gets back to what we were saying before, which is, you say it has to be Mason's legislative procedure, and some other state says, well, no, we want Jefferson's manual, and So I think you can encourage them, but I would be reluctant to specify that they have to vote for every rule is laid out.
Yeah, and that kind of goes back to how much control and where do you want it to go. You clearly could specify it, but if you want to give them some latitude, and yeah, it was interesting working through the rules debate, right? The debate of the rules for the rules convention, but you could see where things were going just from that initial process, and I think that first provision was really critical, right? When we had that delegates cannot propose things outside the scope of their call,
And I mean, that set of rules, while it was geared for a balanced budget amendment convention, could apply to any convention. And I believe the Convention of States project itself has put in place a set of rules that it would propose. So we've got some of these already out there that you would envision. They're first adopted as a preliminary set of rules. Then you turn the Rules Committee loose to report back on a final set of rules.
and in fact, when we came together in Phoenix, we had the Assembly of State Legislatures, we had the Convention of States rules, and we had a number of them coming through. We had a bare bones set of rules that we adopted initially, and then we went to work on that. And yeah, there's so many things to start from. You've got Masons to start from as well. Yes.
Yes, Shelley Hughes, Alaska. I went back and reviewed a piece that I worked on, the Counterman Amendment 2015-16 legislature. I was trying to remember exactly what was in there. It was 7 years ago. And one of the instructions to the delegates was that they prioritize electing a chair president of the convention that was from a state that had called for the convention. And I'm just wondering if you've seen that, if you think that's a good idea. I mean, obviously, if your state is supporting whatever the issue is, you're going to want somebody that's heading up the convention that is a proponent of that. So I'm just wondering if that's a common thing you're seeing or something you'd recommend.
I don't know that there's enough that we can say we're seeing it that specific, because that gets pretty specific. But if you get back to, again, just the way these processes work, if you take a majority of folks that feel a certain way, if the convention's been called, then you're going to want them, it's going to be a majority of those who are in favor of that amendment. And then you pick your leader. And that's kind of the way you do it. We had a very interesting, at the Phoenix convention, we had to go through that process, and it was, it worked out that way, but it all worked out well. And the convention ran smoothly. And Ken was an important part of working through all that and working all that out.
You know what's really interesting, Representative, is the more we have planning conventions, events like this, and you start to know who some of the players are and how they act and interact, and that in itself, even if we were to have a convention that didn't bear fruit of a proposal, to see the delegates from different states and how they interact and how they carry themselves and what that in itself was really, really important. We had the Assembly of State Legislatures, one of their meetings in Salt Lake. I think we had one in Washington, D.C., and one was in Indiana, and then one was in Salt Lake. And just seeing the interaction of the delegates in those meetings alone kind of gave us a head start that when we got to Williamsburg and we got to Phoenix, that's where a number of the delegates already had an idea of who was working and where things were going. And I think to your point, that kind of happens very naturally. Who are the people that have? But it's an interesting idea to have that in the limitation or in the actual application itself.
And then I just have a kind of a technical question. When you held the event, 2017 was it in Phoenix? Those invitations, I didn't know anything about it. I would have made the effort to come. So do those go to the presiding officers, or how was that handled?
It went to the presiding officers.
And was it for the presiding officers to attend, or to appoint someone to attend? Or
each state, the only requirement was that it had to have the approval of the Speaker of the Senate, or the leader of the Senate, who's different states and different people, and the Speaker of the House. And it required both of them to officially appoint one or more people. But the mechanism for choosing was left totally up to them.
So I would recommend next time, if you put out a call, to send it out to everyone, because I can tell you presiding officers gets swamped, and it could have just been something where it wasn't noticed. And yet a particular legislator might be very interested, might be able to get the thumbs up from the presiding officer to attend. So just a suggestion for next time.
No, I think it's a great idea, and I think now NCSL keeps a list of federalism commissions, and then Utah Valley University, their Center for Constitutional Studies, they track the states that have state-federal relations or federalism commissions, and that would be a good thing in most states to send there. But I like your idea, send it to the presiding officers, and then with general notice that it works its way through. I think that's great. Any final questions? Yes.
I have a general question on the automatic recall provision, because I know a lot of people on the opposition, I hear runaway convention. Well, the automatic recall, when you say it, in my mind, I think the person voted badly at the convention, and therefore their state would prefer to have someone else be there. However, they've already done the damage to the process on behalf of their state. So you can't retroactively go back and say, okay, well, that person wasn't doing the work of the state, so you can't undo it.
Actually, the proposal that I was discussing when I was talking about the convention can self-police itself, that was exactly what that was intended for. You have a matrix of what everybody can and can't do, and if someone goes outside of that, then at that point in time, it gets brought to the attention of the presiding officer, and if necessary, the convention votes on whether that vote is valid or not.
Yeah, so that goes right back to credentialing. When they check in, they know the scope of their authority, and that's where we had a secretary that could go through those kind of details. But yeah, no, it's really important that it goes through that way. And if you remember, one of my favorite movies and musicals, and my understanding is it's coming back in 2023, 1776, the musical. And you remember New York showed up and they were there, but they just kept standing up and saying, we abstain courteously, because they didn't have the authority to engage. But in the credential process, you go through all of that, and the secretary would have a list of that. But then again, in a state's limitation, they could put that in, what types of rules you vote for and where you go through, and you have to deliver your credentials, but that happens pretty naturally.
I think the other thing that's significant is, remember, most states are going to have multiple commissioners. And so it will take a majority of multiple commissioners to act outside that scope. And again, under the glare of the lights that we're talking about, I just find that highly unlikely, unless it's Matt Damon, of course, and then he can do whatever he wants.
So in your scenario, the vote would not be accepted.
I would, the fact that they're acting outside their call would immediately be brought to the attention of the floor, or there'd have to be a pause while they determine if that happened, and then. But again, that's going to have to be a state acting outside, because it's one state, even on rules, it's one state, one vote. So there's a process that would have to happen. I know from Arizona, from the Phoenix meeting, that when things like that happened early on, there were a few issues that we were kind of dealing with. We already knew the issues existed up at the dais before it ever got to the floor. So I think you would have something again like that going on here.
Gentlemen, thank you very much. Again, I've learned a great deal, and I thought I knew all there was to know about Article 5, or at least knew a great deal. I'm grateful for your information, for being here. Thank you for the questions. We'll take a 15-minute break. We'll be coming back at 4:30 with Overcoming Convention Apprehension, a bipartisan approach to this Article 5 process. So let's thank our experts, our speakers again. We'll see you in 15 minutes.